sentence you to life in confinement without parole.
That's f***ing horse shit. You do whatever the f*** you want.
Why are they shutting my mic off?
I'm the federal witness of the United States federal government. I demand some goddamn respect, you. All I did was trespass on property.
Ma'am, you gotta create the community that you want to live in.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Okay. For the record, this is going to be position 50 on today's calendar. State of Georgia versus William Harris. Mr. Harris is charged in warrant number 2019 CW 55622 with committing the offense of rape. He's charged in warrant number 2019 CW 55623 with committing the offense of aggravated assault. He's charged in warrant number 2019 CW 55624 with committing the offense of sodomy. He's charged in warrant number 2019 CW 55625 with committing the offense of child molestation. He's also charged in warrant number 2019 CW 55626 with committing the offense of child molestation. And don't have a charge listed for 2019 CW 55627. What is he charged with in this offense?
Cruelty to children in the third degree.
Okay. And I don't have an offense listed for warrant number 2019 CW 55628.
Cruelty to children in the first degree.
Okay.
And Judge, and I just want to make sure for warrant 55626, did you say child molestation or aggravated child molestation?
I have it listed as child molestation, but it's aggravated child molestation.
It is. The warrant lists aggravated child molestation.
Okay. Thank you. Mr. Harris is present here in court. He's being represented by attorney Tiffany Pleasant, who's also here. And the state is being, yes, ma'am.
I just want to make certain for the record, I thought you called out 6 warrants. He actually has 7.
Okay. Let's see, 1.
Ending in 55622. I did not hear that warrant called. I just want to make certain.
Yes, that was the first one. That's the charge of rape. Is that what you have?
Yes.
Yes, Your Honor.
55622.
I just want to make certain. I did not hear that. I wanted to make certain that all of the warrants were read into the record.
And I do have 7 listed. And the state is present, represented by Attorney Shell Freeman. Mr. Freeman, you can swear in your witness and present your case.
Thank you, Your Honor. Detective Baker, would you raise your right hand, please? Do you swear in the front that the testimony about to provide in the case of State of Georgia versus William Harris will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please tell us your name.
I'm sorry, you kind of went out.
Please tell us your name and how you're employed.
Sergeant Baker with the Clayton County Police Department.
And Sergeant, how long have you worked with the Clayton County Police Department?
5 years now.
While working with the Clayton County Department, were you assigned an investigation regarding William Harris?
Yes.
And did this investigation involve a female minor? I'm just going to say the last name of Miller.
Yes, ma'am.
And at the time of these allegations, how old was the female, the minor Miller?
10 years old.
10. Please tell us how the allegations came about.
This was a case that was actually reassigned to me while I was a detective here from another detective. Upon reviewing the case, it was said that the family being the juvenile, her father and her siblings that reside at the 850 King and 850 King Road, sorry. And they had a cousin that visited, a cousin of the father, an adult male by the name of William Harris. Once William Harris left the location and supposedly went back to North Carolina, the victim reported to her father that she was being physically abused and molested by her cousin, which is her father's first cousin.
What was the juvenile able to give a date when these incidents occurred?
She was not able to give exact dates, but she did say it was while he was visiting. She gave an approximate number of times that it occurred and said that it occurred in October or November.
In what year?
This was, I believe this was in 2019. If I'm not mistaken.
Do you have your warrants, Sergeant Baker?
Yes, I would have to get to them to refresh my memory. Sorry, one moment. Okay. And correction on that, it would have been 2018 and reported 2019, January of 2019.
Do you recall, Sergeant Baker, who did the juvenile first make report that her cousin had physically abused her?
She reported it to her father. Well, she did was taken to Southern Regional Hospital and made the allegations there, as well as making the disclosure to her father and her sister, her older sister.
Were you able to speak to her father?
Yes.
After his daughter made the outcry to him, what did he do?
He did have her taken to the hospital in regards to being checked. He did make the report with the police department. Officers were able to respond to the hospital and spoke with the father in regards to what happened or what occurred.
Was a rape kit performed?
A rape kit. I know that she did receive the medical attention at the Rainbow House. Again, it was done prior to being assigned to myself. So I was not 100% sure if the rape kit had been completed, being that it was reported months after being completed.
Okay, and let's go back some. You indicated that the allegations allegedly occurred at, you said 850 King Road. Is that in Clayton County?
Yes.
What did the juvenile victim indicate exactly what her cousin did?
Well, in the forensic interview, she advised that her cousin being the defendant, would get on top of her and he would place his penis in her front and in her buttocks. She also advised that he would force her to touch his penis as well, and that he did this multiple times within the home and at another location that she could not recall what the apartment address was.
Did the juvenile indicate anything that her cousin would say to her?
Yes, she stated that he would tell her to stay still, and also that if she told anyone that he would hurt her or her brother, and that they would end up going into foster care.
When the juvenile victim described what her cousin did, and I know you stated that he would get on top of her, and was she able to say whether or not he inserted his penis in her or not?
Yes, she did state that when he would come into the bedroom, he would pull her pants down and he started doing it in her butt. She stated that he would also place his penis in her front. And once that was gone into within the forensic interview, she did state that he would put his penis into her vagina within the forensic interview.
Were there any witnesses to these incidents?
Yes, the juvenile's brother, who is also a juvenile, witnessed the incident. There were instances where it was not witnesses, but there were a few instances or incidents where she advised that her brother did witness the incident, her younger brother.
Was there a forensic interview conducted regarding the younger brother?
Yes.
And what were the results of that forensic interview?
Her younger brother advised that their cousin would go into he was first advised that his older sister, the victim, told him that their cousin would do nasty things to her, which he first did not believe until he saw it. When they went into detail in regards to what he saw, he advised that he would be in the room and their older cousin would come in and get on top of his sister, and his sister would be crying while he's on top of her underneath the covers. He did witness that he saw or physically saw the cousin's penis, and that he was not able to see the victim completely naked. He just saw that the cousin had his pants down and that he was on top underneath the covers. And as he was on top of her, she would be crying.
From the any type of
Ms. Freeman, you just broke up.
Yes, would you restate that question?
okay. Sergeant Baker, were you able to determine from any of the examinations or the interviews whether or not a condom was used?
Yes, the victim did state that at one time the defendant did use a condom. Then she stated other times he did not.
Did the victim receive any type of medical diagnosis as a result of what happened to her?
Yes, ma'am, she did. She did get a forensic medical done at the Rainbow House along with the forensic interview. And it did turn out that the juvenile had obtained sexually transmitted disease, which she was treated for at the Rainbow House.
At any time were you, Sergeant Baker, were you able to determine with whether or not the defendant had the same STD that the victim had gotten?
No, I was not. I was never able to get in touch or in contact with the victim. I was working around the clock in attempts to get in touch with him and find or locate him, but I was never able to until now that he's in our custody in our jail.
Okay. And just to be clear, because I think you meant to say the defendant, but you said her. I think you said the victim. And so,
I'm sorry.
So just to be clear, I guess let me ask the question again, just to make sure. Were you ever able to determine whether or not the defendant had the same sexually transmitted disease?
Right. I was not able to determine if the defendant did, being that I was not able to get in contact with him.
And since you were able to locate the defendant, have you ever been able to get a statement from him?
No, I was not. I had actually just gotten word that he was within our custody in our jail prior to the hearing.
The 850 King Road, was that where the victim and her father and brother lived?
Correct.
Sergeant Baker, the sexual acts that the victim described, were they all vaginal?
No, ma'am.
What other sex acts did the victim describe?
She described that she was forced to touch the defendant's penis, as well as the defendant placing his penis in her anal area or into her anus.
Did all of this take place in Clayton County?
Yes, ma'am.
Thank you. No further questions.
Ms. Pleasant?
Good. Sergeant Baker, you testified on direct that a forensic interview was conducted, correct?
Yes, ma'am.
When did that occur?
The forensic interview was done prior to the, prior to me being assigned the case. I believe I reviewed the forensic in November. I would have to refer to my notes to find out the exact date. My review of the forensic was November of 2019.
Do you recall who conducted the forensic interview?
Yes, ma'am. It was our forensic interviewer at the time, Ms. Nikisha Weekle.
And you indicated the younger brother, what is his age?
I believe he was 8 years old at the time.
And was Ms. Yeager responsible for conducting both forensic interviews?
No, ma'am.
Who conducted the younger brother's forensic interview?
That would have been Miss Wendy Mulder.
So when was his forensic interview conducted?
To get the exact date again, I would have to refer to the notes, but that was after myself being assigned. So that would have been in 2019, after being reassigned the case.
So his forensic interview was not conducted at the same time as Ms. Miller's?
No, ma'am, it was not.
And were both of these interviews conducted by the Rainbow House?
Yes, ma'am.
And what was the date range of these alleged incidents?
She advised that it happened in the months of October and November.
Of what year?
2018.
Now, the 850 King Road address, who resides at that location?
The father, along with his children, he has an adult daughter that was there at the time. His younger juveniles, 2 younger juveniles, the victims, and I believe the victim's grandmother.
And where was the adult daughter when these alleged incidents were occurring?
I cannot speak on where exactly she would have been at the time of the exact incidents, but I believe she did work, if I'm not mistaken.
Was she interviewed in regards to these allegations?
Yes, she was.
And the same question for the grandmother, where was she when these alleged incidents occurred?
I cannot recall where the grandmother was. I just know that they were not able to be at home at the time that the father was at work. So we had to get someone to watch it.
Okay.
I'm sorry?
Was she interviewed in regards to these alleged incidents?
The grandmother was briefly interviewed, yes. She was not brought in for a full interview. She was just briefly interviewed in regards to what she knew, which wasn't much.
Okay, so not much, but what did she say?
Nothing in regards to what she knew as far as the incident, other than what the children told her that occurred.
And when did the children make a statement to the grandmother?
I cannot give an exact date as to when they made the statement to the grandmother.
Was it before or after the daughter was taken to the hospital? The alleged
I cannot say for certain if it was before or after.
Okay, same question regarding the adult daughter. Were any statements made to her about these incidents by the alleged victim?
Yes, the victims did make the statements to the daughter when it was disclosed in regards to what happened initially, or while initially, meaning when the incident, prior to the incident being reported to uniform officers.
Okay. So prior to going to the hospital, but you don't recall when exactly that the alleged victim made a statement to her sister?
Right. I cannot recall if it was prior to going to the hospital. I do know, again, being that it was reassigned to me, I can't recall if it was prior to going to the hospital, but I do know that she did disclose to her sister prior to uniform officers.
Okay. And you're not certain whether or not a rape kit was performed?
No, I would have to refer to the notes from the prior detective in regards to it, being that it was so long ago. Now, I will say that the forensic medical does have that as well. I don't know if Southern Regional did do a rape kit, but within the forensic medical, there were the same practices done by our forensic medical examiner who was able to provide the medical results for that medical review.
So Southern Regional, what, if anything, did they report with regards to sexually transmitted diseases involving Ms. Miller?
Southern Regional did not report that. That's why I'm stating, because I cannot say for 100% certain, but Southern Regional doesn't typically perform those kind of medical examinations on the juveniles once they have those kind of allegations. So I did not receive any information back from Southern Regional in regards to an examination or in regards to any kind of results that they obtained.
Okay. And going back to Ms. Miller's father, what information, if any, did he provide regarding why Mr. Harris was residing with him?
He advised that Harris visited in regards to watching his children while he was at work, since he did not have anyone or any adult supervision at the home while he was out at work.
And did he give the date range for when he was visiting?
I believe he may have, but I cannot recall off the top of my head. I would have to review the notes or my case file to get the exact dates.
Thank you. That's all I have, Your Honor.
Any follow-up?
No, Your Honor. State rep.
Okay, may Sergeant Baker be released?
Yes, Your Honor.
Sergeant Baker, you may be released. Thank you for your time. Ms. Pleasant, do you intend on calling any witnesses?
No, Your Honor.
Do you have any argument?
The state will waive opening.
Okay,
No, Your Honor.
okay. I'm gonna find that evidence is sufficient to bind these 7 charges over to the Superior Court of Clayton County for trial. Mr. Harris, stay in contact with your lawyer. Mr. Harris may be sent back at this time. The next case is, excuse me, it's gonna be Patterson.
Yeah, we're working to get that officer.
Okay, so we'll take about a 5-minute break while you try to reach out to your officer.
Judge, and don't forget to go off of YouTube.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
I try to, if I know that an officer is coming off an overnight shift, I try to get that person in and out and go home and go to bed. Okay, we have the YouTube live up and going. For the record, this is State of Georgia versus Luis Arturo Villafranco. Mr. Villafranco is charged in warrant number 2022 WA 05560 with committing the offense of criminal trespass. He's charged in warrant number 2022 WA 05561 with committing the offense of terroristic threats or acts, and he's charged in warrant number 2022 WA 05562 with committing the offense of aggravated assault. Mr. Villafranco is present. He's being represented by Attorney Keith Wood. The state is here being represented by Attorney Cheryl Freeman, and Officer Golden is present. Ms. Freeman, you may swear in your witness and present your case.
Thank you, Your Honor. Officer Golden, would you raise your right hand, please? Do you swear and affirm that the testimony provided in the matter of State of Georgia versus Luis Arturo Villafranco will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please tell us your name and how you're employed.
My name's Robert Golden, and I'm employed with Clayton County Police Department.
How long have you worked with the Clayton County Police Department?
Just over 2 years.
Were you working with the Clayton County Police Department on March 27th of 2022?
Yes, ma'am.
On that date, did you respond to 2821 Mount Zion Road?
Yes.
Can you please tell us what type of establishment is that?
It's a banquet hall. They host like quinceañeras, birthday parties. It's an event hall.
Okay. Why did you respond to that location?
We responded to a call there in reference to a male refusing to leave, and that same male was also yielding a knife and threatening partygoers and the security on scene at the banquet hall.
When you arrived at the location, Officer Golden, who did you speak with?
I spoke with Mr. Juan. He's the head of security for the business. The business is La Mansion. It's the Spanish name. He's the head of security. That's who I spoke with. He's the one who called 911.
Okay. And what did Mr. Juan tell you that happened?
He said that there is a Hispanic male who had shown up.
Judge, I'm just gonna throw out an objection there as to hearsay.
Overruled.
Go ahead, Officer Golden.
So yeah, I responded to that business. I met with Juan, the security. He advised that there's a Hispanic male there. He refused to leave when Juan asked him to leave. At that point, the male pulled out a knife, was acting belligerent and threatening the people that were attending the parties on both sides, and was ultimately threatening security.
Was this male still on the premises when you got there?
No, he had left in a car with an unknown man.
Did you speak to any other witnesses at the location?
No one else wanted to speak to law enforcement that was on scene.
You indicated that this male was making threats and pointing a knife. Can you be specific as far as who did he point the knife at? And what
Yes, he directly pointed the knife at Juan, the head of security, and was making gestures with his hand to his throat and threatening him, saying he would harm him. Just making threats at security that he was going to cause bodily harm to them.
When this male made the threats against Juan, was Juan able to say if there were witnesses who heard those threats?
He said that there were plenty of people present around him when this all took place. But again, the people that were there, no one wanted to cooperate with police. No one else wanted to come forward and say anything.
Okay. Did any of those people corroborate that there was a male running around with a knife?
Yes, multiple partygoers.
You know, she asked, Ms. Freeman asked the officer, did anybody corroborate? Anybody talk to the police? And the officer said no. So now we're just asking the same question a different way.
Judge, I don't believe so. The officer said that no one wanted to give any statements, but I'm asking, did anybody corroborate that someone was running with a knife? I think what the officer is saying is there were people who gave statements, but they didn't want to give their identity. And I'm just trying to make sure that I want to be clear for the preliminary hearing.
And Mr. Wood, for the record, I'm going to overrule the objection. I heard two separate questions asked. So yes. So go ahead, Officer Golden.
Yes. So in regards to your question, ma'am, people that were on scene advised, yes, there was a male acting irate, waving a knife around. But when I asked, would you guys mind writing a statement? No one wants to write statements. People, they just didn't want to cooperate, but they did say, yes, there was a male here with a large knife waving around the party hall.
Okay. Were you able to to apprehend this individual who was waving the knife?
Sector 4 officers were able to apprehend the offender in a different sector of the county based on the Bolo that we put out, based on the information provided me from Juan, the security officer.
And just because we're recording, when you say the Bolo that was put out, can you explain what that is?
Oh, Bolo, be on the lookout.
Do you recall what information was placed in the Bolo?
Yes, it was Juan advised that the Hispanic male had gotten into a red Chevy truck, car, an older model red Chevy. A male had shown up and picked him up. He advised the male that picked him up was not at the party, and that he got in that truck and he went north on Mount Zion. And literally about 10 minutes after I put it out, a Sector 4 K9 officer said, "Hey, I'm behind a car that matched that description," and the rest is from there.
Sir, do you know if a knife was recovered?
Yes.
It was recovered?
Yes, ma'am.
Was it placed into evidence?
Yes, ma'am.
Are you aware of whether or not the person who was apprehended made any statements about what happened?
When I don't know if what he spoke to the units that located him. I don't know what statements he made to them. I know they did supplemental reports that were submitted on this, but once he was brought into my custody, he was just advising stuff about being in federal witness protection, and it kind of just stuff that was up in the air that really had nothing to correlate with what was going on.
What can you tell us what those things were that he said?
Yes, he said that he was in a federal witness protection program, and something along the lines of earlier, he had saved a woman from a burning car, and he refused that. Like I said, he refused to answer questions about the incident that took place, the reason police were called. He was just talking about, again, federal witness protection and saving somebody from a burning car and being some type of savior. It didn't really have anything to do with what was going on, but I just documented it because that's all he would tell me.
Okay. Were you able to confirm that the individual that was apprehended was the same person that Juan had reported was running around with a knife?
Yes.
Did Juan do a photo lineup or anything like that?
Just based on the description that Juan provided, and based on the vehicle description and the description of the subject, we were able to determine that was the male.
Did all of this take place in Clayton County?
Yes, ma'am.
Thank you. That's all I have.
Attorney Wood.
Yes, Your Honor. All right, so Officer Golden, you've been employed with Clayton County for 2 years, right?
Correct.
Okay, and you responded to this call out there on 2821 Mount Zion Road, correct?
Correct.
All right, and you didn't observe anything that happened there this evening, is that correct?
In reference to this incident, correct.
All right, and do you have any idea of whether or not Mr. Villafranco was invited to this party?
No, I have no idea if he was invited to one of the two parties that were being held at the banquet hall.
Okay, and everything that you testified to as to whether or not he was acting belligerent, you don't have any personal knowledge of that, correct?
No, just based on what I gathered during my investigation while on scene.
All right. Now, you testified earlier that no one wanted to speak. You testified that no one wanted to speak to law enforcement officers, but then you changed and you said, well, they spoke to me, but they didn't want to give their ID. Is that correct?
Yeah, no one wanted to give a statement, correct?
No, what you said when you first started was that no one wanted to speak to law enforcement officers. Do you remember saying that?
Yes.
Okay. And then you changed your testimony later saying, when you were asked about corroboration, you changed your testimony and said, well, they spoke to us, but they wouldn't give us their ID. Remember saying that when Ms. Freeman asked you?
They wouldn't give IDs or write statements, correct?
Okay. All right. And so who did he specifically threaten?
Well, he threatened the security guard, Juan. He was the only one that would talk to law enforcement about it. But according to security, he was waving a knife around, yelling and threatening people at the party.
Okay. So you don't know any specific person that he threatened?
He threatened security.
Did he attack security? Did he come at him with a knife, or was he just standing there waving a knife around?
He was looking at security, holding a knife, making threats towards them.
How much distance was between Juan and the security officer?
Juan did not provide a distance between him and the Mr. Gutierrez or Villafranca.
So you don't know if they were like right in each other's face or whether they were at opposite sides of the parking lot, possibly yelling at each other, do you?
No, he said it all took place in the entrance of the banquet hall.
Okay, but you don't know how close they were.
No, I don't have any distance.
Did Juan tell you that he was scared that he was going to get stabbed?
He said he was in fear for his life, that a man was waving a knife in front of him and threatening him.
And did you write that in your police report?
Yes, I wrote that he was in fear for his life.
Can you point that out where it was in fear, where it says, do you have your police report with you?
I do.
Can you tell me where it said that Juan was in fear for his life?
He said his life was in danger and advised he feared that the subject was either going to harm him or other people at the business.
So I'm asking you, where in your police report did it say that Juan said he feared for his life?
I'm going to object. I believe Officer Golden just answered the question. And I think at this point, Attorney Wood is just a play on words. Officer Golden read to Attorney Wood what he put in his report. I think he's answered the question.
And Judge, my response would be, no, he didn't read what was in his report. I asked him to read what was in his report. He didn't even look at his report. And I've got his report right here in front of me.
I have the report as well. And what he just said, I'm looking at it in the report.
I don't see where it says that. Okay, so Judge,
go ahead.
The crux of the argument is that Mr. Golden said he told Juan he was going to kill him, and Juan said that he was in fear for his life. I don't see that in the police report. I see where he says something about Juan advised that he would threaten him and was threatening people inside the business. Says Juan advised the subject, said he would come back and kill everyone. I'm just asking Mr. Golden, where does it say that Juan said he feared for his life? And I don't see it in there.
Judge, Officer Golden's response, and he read exactly what he put in his report. He stated that Juan said he felt his life was in danger. He advised that he feared that the subject was either going to harm him or the other people at the business. That was the response given by Officer Golden, because that's what he has in his report.
Is that in the report, Attorney Wood?
I don't see that, Judge. I asked the officer to tell me where it was in the report, and
okay.
All I got to say.
Okay, well, I don't have the report in front of me, and it seems like there's a difference of opinion as to what is exactly in the report.
That's all right, Judge.
However, it seems to be a distinction without a difference. There's testimony that your client allegedly had a knife, and allegedly waved the knife at least in one's direction. And I would believe it would be reasonable for a person to have some kind of fear about that. That's what I'm getting from the testimony of Officer Golden. Now, of course, if this were a trial, one would be the person that you would be able to ask those questions of.
I understand, Judge. I'll move on to my next question.
Okay.
All right, so Officer, just to follow up on a question that I asked, nobody wanted to come forward and assist. That's correct, Officer Golden?
No one wanted to come forward. Yeah, come forward and provide statements and possibly be a victim in this incident. Correct.
Okay. And so after you arrived, you put out a Bolo, be on lookout, correct?
Correct.
And apparently Mr. Villafranco was later picked up by officers in Sector 4, correct?
Correct.
Okay. Do you know how many people were in that red Chevrolet truck?
Yes, the driver and Mr. Villafranca was in the passenger seat.
Okay. And your testimony was that his knife was recovered. Is that correct?
Correct.
And when you're saying his knife, who are you talking about? Mr. Villafranco or the other gentleman who was driving the truck?
Mr. Villafranca's knife.
Okay. And how do you know it was Mr. Villafranco's knife?
That was the only knife recovered in the vehicle.
Okay. But how do you know that it was his knife?
You would have to look at the other officer's supplemental and see. I'm pretty sure the other officer wrote in his supplemental, he located the knife on the person.
Okay.
I don't have that supplemental in front of me.
Okay. All right. So did anyone ever take that knife back and show it to Juan Heenan, the security director?
No.
And following up with what Ms. Freeman asked you, nobody ever took the defendant over to La Mansion or to the incident location to get anyone to identify Mr. Villafranco, correct?
Correct.
And no one even took the other driver, the driver of the vehicle, nobody took him over there to see if anybody could identify him. Is that correct?
Correct.
So we don't even know if we have the correct red pickup truck or the correct person. Is that correct?
You could say that.
Okay. And you mentioned he was saying something about something that didn't make sense about anything. He just refused to answer your questions, right?
Correct.
And he didn't say anything about being a savior. What he actually said was that he was a man of God. Is that not what he said?
Correct. That he was, I'm going to read the sentence. He further advised he was out saving a lady that was in a burning car, that he was a man of God. He refused to answer any questions about what actually happened that night.
Okay. Well, that's a little bit different from talking about being a savior. Is that correct?
I mean, yeah, out saving people, being a savior, man of God.
Okay. All right. All right. That's all I have, Judge.
Any follow-up?
No, Judge. State rest.
May Officer Golden be excused?
Yes.
Yes,
Thank
sir.
you, Officer Golden.
Thank you, Officer Golden.
That's all.
You can be excused. Do you
Thank you,
have
Judge.
any witnesses, Mr. Wood, that you're going to put forward?
No, Your Honor,
Do you have any argument?
just a little bit.
But the state waives opening.
Okay, go ahead, Mr. Wood.
All right, well, Judge, as far as the criminal trespass is concerned, if someone is invited to a location, you know, and he's there attending a party, you know, the person I think that invited him over there is one that has to tell him to leave.
Yeah, don't object. There is no testimony that the defendant was ever invited to the party.
Well,
Hold on. I understand your argument, Mr. Wood. From a criminal trespass standpoint, the testimony that I heard was that he was asked to leave and refused to leave.
Hmm.
And that is when, even if the person was invited, if they were asked to leave and they refused to leave, that's when, my understanding, criminal trespass comes into play.
okay, well, I'll move on.
Okay, go ahead.
Judge, as far as the terroristic threats, you know, there has to be some type of corroboration with terroristic threats. It just can't be somebody's statement. You know, the officer first said that no one would talk to him, said that no one wanted to cooperate, and only after redirect by Ms. Freeman did he say, well, they talked, but they didn't want to give statements or their ID. Well, to me, that's no corroboration. I mean, there has to be somebody that can corroborate the statement of a threat. He also has to, you know, threaten them with a crime of violence. I mean, just because somebody may be there and waving a knife around doesn't mean he's threatening a particular person. And that would use that same argument as far as the aggravated assault. You know, you have to be in the process of committing an assault for it to be aggravated assault. So, Judge, there's no evidence that he was actually threatening any particular person. You know, it's like, what is the state going to put in their accusation? Did threaten a bunch of random people that didn't come forward? Or, you know, we have to put different names in there. We have to put somebody that he actually threatened, but, you know, we don't know anyone he actually threatened except some statements that Juan said, and the officer didn't even know whether Juan was close to the guy or, you know, whether he was in his face, whether he was 6 feet away, whether he was at the other side of the parking lot. You know, he said he didn't know. So I don't know how he can make a threat. Against him, number one being no corroboration, and number two being there's no evidence that an aggravated assault ever took place. You know, just having a knife in your hand and waving it around is not aggravated assault, Judge. So that would be my closing argument. So I'd ask you to dismiss all these charges.
Okay. The knife can constitute an aggravated assault, because you don't, in my understanding, correct me if I'm wrong, you just have to have a weapon that, if used offensively, can cause great bodily harm. You don't actually have to stab somebody.
Well, but you
That's correct, Judge. And just with my argument, and since Attorney Wood has made his argument, and I believe the state gets the last word on it, we're asking that all the charges be bound over based on the testimony of Officer Golden, the actions of the defendant with the knife, believe certainly constitutes terroristic threats based on there were witnesses there. His actions with him waving the knife at the security guard is certainly enough for aggravated assault. He instructed the defendant to leave the premises several times. He refused to leave. So we certainly think that there was a criminal trespass as well. And so certainly there may be other issues that Attorney Wood can raise in Superior Court, but for purposes of the preliminary hearing, we believe that there is sufficient testimony to bind all the charges over.
From what I heard, I believe there's clearly enough at this low stage for the criminal trespass, aggravated assault, terroristic threats. I think it's the one that I had the most problem with. But I believe the testimony of Officer Golden about what Juan said, I don't think it's the best, but I believe at this stage is something to, it's enough for it to be bound over. So I'm going to bind over all the charges. And I think, you know, Mr. Wood, you may have a strong case at trial. Because I mean, unless Juan is a great witness, it may be a problem at trial, but it's enough to pass over. So I'm going to bind these 3 charges over to the Superior Court of Clayton County.
Thank you, Judge.
Thank you, Judge. May we be excused?
Yes, you may be excused, Mr. Wood, and have a good
And
day.
Judge, thank you so much for taking me first. I don't deserve that. Thank you anyway.
Well, I try to be fair, because now Miss Freeman's time is going to be taken up with Mr. Rogers and Miss Davis and Miss Pleasant, Miss Hill. So I am going to place you all in a breakout room with Miss Freeman. And as always, I will turn my camera off, but I'll be around.
Thank you. And Judge, take us off of YouTube.
My wife told me I wouldn't be done till after 2, and I did not believe her. But
Judge, I also want to just remind you real quick, we still have the dismissal for you to rule on for Lark Kemp.
For Kent, that was the person where the officer wasn't present, correct?
That's correct, Judge.
Okay, we will address that after Mr. Gibson, okay?
Sounds good.
So for the record, this is State of Georgia versus Terry Gibson. Mr. Gibson is charged in warrant number 2022 WA 06461 with committing the offense of theft by shoplifting. And he has a $6,500 bond. Okay. Mr. Gibson is present. He's represented by Miss Attorney Hill. She's present. State is being represented by Attorney Freeman. She's present. Ms. Freeman, you can swear in your witness and present your case.
Thank you, Your Honor. Officer Molina, can you turn on your video and unmute yourself? Would you raise your right hand? You swear and affirm that the testimony about to provide in the matter of State of Georgia versus Terry Gibson will be the truth, the whole truth, and nothing but the truth, to help you God.
So help me God.
Please tell us your name and how you're employed.
Officer Emmanuel Molina with the Riverdale Police Department.
Sir, how long have you worked with the Riverdale Police Department?
A little over 2 years.
Were you working with the Riverdale Police Department on April 12th of 2022?
Yes.
And on that particular day, were you dispatched to the Walmart at 7050 Highway 85 in Riverdale, Georgia?
On that particular day, I was working in off-duty department authorized detail.
I'm sorry, okay. And were you working off-duty detail at that location?
Yes, ma'am.
And did you have occasion to come into contact with a Terry Gibson on that day?
Yes, ma'am.
And please tell us how that contact came to be.
Walmart's loss prevention officer, Mr. Williams, contacted me on my phone while I sat in my patrol vehicle in front of the establishment, in front of Walmart, and notified me saying that there was a black male subject wearing a gray hoodie, black mask, and black pants who exited the garden center area of Walmart with 2 shopping carts, one with a television and the other one with 2 black and colored backpacks filled with
unpaid items. He passed all points of sale, and that he was stationary, standing at the MARTA bus stop on Lamar Hutchinson Parkway and the private access road into Walmart. So I drove to that area where he advised the subject would be standing, and I observed Mr. Gibson standing next to two shopping carts. I ordered him to get on the ground, and he complied. Mr. Gibson complied the entire time of contact. I detained him. Further investigation revealed that he passed all points of sale with 37 unpaid items totaling $738.16. Further investigation also revealed that Mr. Gibson has quite a rapport with multiple Walmart locations. He's got over 10 cases where he's logged into Walmart's recording system of theft by shoplifting. And apparently it seems that he steals the items to sell them onto the street, which he tried to sell to a semi-truck driver who was next to the MARTA bus stop. That driver advised me that Mr. Gibson tried selling him the items that he had just walked out of Walmart with, but that driver refused to fill a witness statement for him. He wished to be anonymous.
Were you able to recover all the items that Mr. Gibson had taken from Walmart?
Yes.
Did Mr. Gibson make any statements regarding the items that were taken?
He did not make any statements regarding the items, no.
Was there video surveillance of Mr. Gibson, I guess, going past all points of sale?
Yes, that video surveillance is recorded and kept in storage by Walmart and the loss prevention office.
Did all of this take place in Clayton County?
Yes, ma'am.
I have no further questions. Thank you.
Ms. Hill?
Thank you, Judge. Let's see. Just 1 second. All right, Officer Molina.
Yes, ma'am.
When you arrested Mr. Gibson at the bus stop, was he the only person standing at the bus stop?
I recall possibly two other subjects, but they were not fitting the description given to me by the loss prevention officer.
Were they also Black males?
I believe one of them were, the other one I could not recall.
Okay. Could you go through again and describe the type of clothing that you described the person as wearing, the person who left Walmart with the items? Because you went through that kind of fast. Could you restate the type of clothing?
Yes, gray in color, long sleeve hoodie, and a black mask and black pants. I forgot to mention the loss prevention officer himself did come out there and identify Mr. Gibson.
Now, the loss prevention manager, I believe you said his name was Mr. Williams. Did he see, was he watching the video or did he actually see Mr. Gibson? Which one is it?
He was watching on video in the loss prevention office.
Okay, he was watching on the video.
Yes.
And so then Mr. Williams came outside to the bus stop and identified Mr. Gibson?
Yes.
Okay. And how clear is the video surveillance that Mr. Williams would have been watching?
They just installed new cameras that I believe are 4K, so they're extremely clear. You could probably read someone's text messages if you wanted to.
Okay. And let's see, Officer Molina, when you encountered Mr. Gibson on the street, did you said that the carts were right next to him?
Yes, ma'am.
Okay. With the list of items, I believe, that are included in your police report, these are all the items that were found in the cart?
There was a television, it's still in the box, obviously, when you get a new TV. That was in one of the carts, and the other cart had two black in color backpacks that were filled with miscellaneous items like lotion, soaps, deodorants, etc.
Okay. And did you ask Mr. Gibson whether or not that cart belonged to him?
I did not, because the loss prevention officer advised me that Mr. Gibson was the one who exited the garden area
Okay. And
with those carts.
And you reviewed the tape and you saw him exit the garden area with the cart?
Yes. Later on, when I came back from the jail.
Okay. Let's see. No further questions, Your Honor.
Any follow-up, Ms. Freeman?
No, Your Honor, the state rests and Officer Molina can be excused.
Okay, sir, you can be excused. Thank you for attending. You can remain if you want, but it's totally up to you.
Thank you, Your Honor.
You're welcome. Any argument?
Yeah. Oh, yes, I'm assuming the state waives opening.
Uh-oh. Looks like she's frozen.
No,
Oh, okay.
you might.
Yes, you're back. So you're gonna waive opening?
I am, and Judge, I apologize again. I'm in the office, and it keeps, my message keeps saying internet unstable, but I'm in my office in the building.
Hey, I know the place well, so I understand. Ms. Hill?
Yes, Your Honor. Your Honor, I'm gonna ask the court to dismiss this charge or to reduce it at least to a misdemeanor, because I didn't hear much testimony as to the amount.
I thought I heard over $3,000.
Oh, sorry, I might have missed that. Maybe it froze up. That was a moment where I froze up. Okay.
Oh. Okay. But I did hear, I think it was over $3,000 was the testimony.
Okay. Thank you. I
He
think I missed
testified
that.
about he gave the amount that's listed in the WA, the $738.16.
Okay, I'm sorry, I missed that
Okay.
then. Thank you. I
Okay.
definitely knew that, or I would have examined him over that.
Okay.
Your Honor, I'm still gonna ask that you dismiss these charges. I mean, he walked outside and he saw, they saw my client standing at a bus stop and they saw the items next to, at the bus stop, in a cart. I guess that looks like him, but he was just standing there. It could have been, it's a very vague description. Sweatpants and a black hoodie, black shirt. I think it could have been one of many people to have done this. However, just because my client seemed to be at the wrong place at the wrong time, I think he kind of just got a bad rap on this, Your Honor. So I ask that you dismiss.
Well, that's possible, but the testimony I heard was that he fit the description of the person that was seen leaving the store. So that makes it more likely than not that he could be the person. Of course, I don't have the video to make that determination, but I'm allowed to rely upon the testimony.
Yes, Judge, and that's what the state, and based on the testimony provided by Officer Molina, we are asking that one charge is bound over.
Yeah, I think it's sufficient to bind it over to the Superior Court of Clayton County. So that's going to be my determination. Before we get to Mr. Kemp, I was going back through my calendar.
And Judge, may Officer Molina be excused?
Yes, Officer
Okay.
Molina, you may be
Officer.
excused.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Public defender waived her appearance. Medical reasons. Thank you. Jordan Medina. Please say your name. Jordan Medina. Again? Jordan Medina. Thank you. Mr. Medina, you were arrested for petty theft, possession paraphernalia, possession of cocaine, Possession with intent to sell or deliver cocaine, there is probable cause. PTR, any history?
Your Honor, he has a no valid driver's license out of Polk County in 2019, which was an adjudication withheld. He has extensive history out of New York for drug paraphernalia, robbery, grand larceny, assault, possession of a weapon, petty burglary. His most recent offenses were in January of this year for robbery and possession of a weapon and disorderly contact. He was conditionally discharged for that.
What do you mean by conditionally discharged? Is that from up north or from down here?
From
So whatever their language means.
yeah, whatever. They're
Mr. Medina, have you ever been found incompetent by a judge or a doctor? No. Okay, and how long have you been in Kissimmee?
4 years.
How many?
4 years.
4, okay. All bonds will be stayed. 250 count 1, 500 count 2, 2,500 count 3, 7,500 count 4. He qualifies for PTR with bond, so the court's going to add PTR supervision. No contact with any listed co-defendant. If there was a that says observed unknown Hispanic, I don't think there was a co-defendant. Okay. No return to any Walmart. Do not possess or consume any illegal substances. Do you need a public defender?
Yes.
You can delete the no contact with co-defendant. PD provisionally appointed. Next court date?
On demand.
Thank you. Kennedy Walton. Please state your name, sir.
Kennedy Walden.
Mr. Walden, you were arrested for trespass on property other than structure conveyance. There is probable cause. PTR, any history?
yes, Your Honor. He has history dating back to 2019 for robbery out of Polk, which was dropped. Resisting without violence, he was found guilty. Time served out of Polk. Multiple resisting without violence, trespassing. Most recently in February of this year, he was found guilty for that as well.
Do you know if it was the same location?
No, Your Honor. They were all out of the same county, Polk.
According to the risk assessment sheet, he qualifies for direct PTR?
Yes, Your Honor.
All right,
Based
Mr.
on
Walden,
the
you're going to be released pretrial release. You may not return to any racetrack gas station. Do you need a public defender?
Yes.
PD will be appointed provisionally. Next court date?
On demand.
That means they'll let you know. Thank you. Tremel Williams. Please state your name, sir.
Williams.
Thank you. Mr. Williams, you were arrested for domestic violence battery. I've read the affidavit. There is probable cause. PTR?
Yes, Your Honor. He has a driving without a valid driver's license in 2019. He was found guilty for that. He served 5 months of probation. He later had an FTA in that case later on in 2019.
Sir, your bond is going to be set at $500 with pretrial release supervision. No contact with listed victim. No return to the address. You can have a one-time assist order to get your personal belongings. No weapons or firearms. Do you need a public defender?
Yeah, so even though my name is on the lease too, I can't do that?
Correct. For now. PD will be provisionally appointed. Next court date?
On demand.
That means they'll let you know, sir. Thank you. Nathan Rodriguez, also known as John Doe 3193. Good afternoon. Please say your name.
Nathan Rodriguez, Your Honor.
Thank you. So, Mr. Rodriguez, we were able to get, I guess, a copy of your school ID and information that had your picture and your name and all that on it. So that was good. And if I remember PTR yesterday saying they ran that name and they had not really found anything, probably because you're so young. I'll let them tell me if there's anything new.
Yeah, Your Honor. We did run it this morning. He has no history in state or out of state, and we did provide the court with his school records and birth certificate.
Yeah, like I told you yesterday, my biggest concern was just making sure we knew exactly who you were, because I didn't want to run the risk of letting somebody I didn't know out on the street who could have had a very violent history. And now that we know who you are and you don't have a criminal record, that's good. So let me ask you, how long have you been in Kissimmee?
I came on vacation literally only like 2 days.
Okay, and you're going to go back to New Britain?
Yes, ma'am.
All right, and you have family you can stay with there?
Yes, all my family's in New Britain. My mom's here to give me.
Okay, he doesn't qualify for PTR?
Your Honor, he does qualify for direct PTR in both cases.
Okay, on both?
Yeah, by the time we sent you the paperwork, we hadn't received his documentation yet.
State any objection based on all that info that we know now to the recommendation on the risk assessment sheet of direct PTR?
No objection, Your Honor.
All right, so I'm going to release you, pretrial release. You can go back to New Britain with your family. You have to stay in touch with the PTR office. You can stay in touch on phone or video. You can FaceTime or whatever they set it up, but you got to stay in regular contact with them, and you got to stay out of trouble. Do you understand?
Yes, ma'am.
All right, and you might have to come back for court at some point, but your lawyer will let you know when and where.
All right, thank
Do you need a public defender to represent you?
Yes.
Did you fill out the form, the financial questionnaire?
Yes, ma'am.
All right. I haven't gotten it yet, so PD will be provisionally appointed. You must keep in touch with your lawyer and pretrial release, okay?
Yes, Your Honor.
All right. So your family can pick you up at the jail later today.
Thank you very much.
You're welcome. Stay out of trouble.
Your Honor, would you like weekly contact or monthly?
Weekly would be great, just to make sure, because they're serious allegations, but
Okay.
based on him not really having a significant history and his family sweating bullets, they're going to keep an eye on him and make sure he stays out of trouble. Don't let him use the car. Bye. His family was here in the courtroom. Yeah. All right. So besides Johnny Mejia, is there anybody else that I missed? All right. And everybody else is out of there. We're good to talk?
That is correct,
All
Your
right.
Honor, and I was informed that Mr. Mejia's mother does need a Spanish interpreter.
Okay. Where is she? She's not here.
She's out.
Oh, she's outside. Okay. She's not the victim. She's probably coming to tell me about his condition, which.
Yes, Your Honor.
All right. I don't need her. She can come in and listen if she wants to, but she's not the listed victim.
I already told them to come in.
Yeah. If I need to hear from her, then I will call her in, but we need to address this. So, hey there, Ms. Hill. Give me 1 second. So, Mr. Mejia, say your name. Okay, Mr. Mejia, how old are you? All right, just making sure you're not under 18 because otherwise I have to let your mom come into the courtroom. All right, so is the public defender seeking provisional appointment?
Yes, Your Honor.
Have you had conversations with his family indicating that they would need the services of the public defender?
That is correct, Your Honor, as well. For the court's information, the victim's mother is outside of the courtroom as well.
Okay, thank you for that info. So she can come in. Hold on 1 second.
The victim's mother.
Her name is Yeager Mejia. So she can come in. She has the right to hear what's going on. PD provisionally appointed, yeah. No, she could just sit in the audience. This is Miss Yeager Mejia? No, Haritza Mejia. Miss Delgado can sit and listen if she wants to, but Miss Haritza Mejia is the mom of the victim, alleged victim, and the sister of Mr. Mejia Delgado. She's not out there? No, it's my daughter. Yeah, I understand. You can have a seat. Thank you. Okay. There's nobody else out in the hallway. It was just Mr. Mejia's mom and a gentleman who's with her. Okay? All right. Thank you. Sir, have a seat. And you're not allowed to use the phone in the courtroom. No phones in the courtroom. Thank you. Yeah, the deputy just called the halls again and the other lady's not out there. If she comes in, of course, she has the right to be here. And the mom and the other gentleman are in here listening as well. Okay, so let me just, we have an empty jail room, right? Just you guys? Okay, and the courtroom is just the people that I've indicated, the State Public Defender's Office, PTR, and us. All right, so Mr. Mejia was arrested for sexual battery on a person under 12 by a person over 18 years, chronological 18 years. My understanding, based on the information that PTR was trying to get over to me, that Mr. Mejia has some issues and his mental age is much younger than his physical age. That's correct. Okay, so Ms. Hill, I've waited until right now because whatever else info that you have for me needs to be said on the record, as would be whatever it is the public defenders are trying to get me to see. Sending them to my chambers or sending them to court admin is an ex parte communication that I'm not allowed to engage in. Any info that I get beyond the police report and the risk assessment has to happen in the courtroom so that all parties are getting the same info at the same time. And I'm not accused later of getting side details. Not that Ms. Hill meant that. I know she would never mean that. She's done this for a real long time. But just because of the nature of the type of charge, I wanted to make sure we were all together when any of this info was given. So having said that, Ms. Hill, you may proceed.
That's completely understood, Your Honor. He has been diagnosed with many disabilities, and I don't know if you would like me to state those disabilities.
You can if you'd like to. I mean, how did you get the information?
I got the information from our mental health director as well as the mother, and you received paperwork that has this diagnosis as well, so I don't know if I necessarily need to repeat that on the record. However, our mental health director has placed a Baker Act hold in the system, and upon reading all the information and making a determination, we would be hoping that you would be inclined to ROR him directly to Park Place so that he can get the adequate care that he needs, because his medication is quite extensive and it's unique, and the facility does not have access to the medication that he is required.
I appreciate that information. Yes, those things do need to be on the record. The record never has information hidden from it. What we try to do is protect the privacy interests in some situations, and that's why we limit the people who are overhearing what we have to say. But the record always gets the most appropriate and the most accurate and the most detailed info. So if you know of his diagnoses, you may say it because it's kept confidential within who's here.
Yes, Your Honor. So he has autism spectrum disorder, intellectual disability, bipolar, schizophrenia. The report from the specialist states that he has been home for 3 months. He appears to be at baseline. He has some difficulty with the emotional outburst related to his missing father. And basically the medication is quite extensive, and if he does not receive some of it, he is susceptible to violent behavior. However, the family is able to keep him with his medication stabilized. But their concern is if he's not receiving the needed medication, which is Abilify, which is a shot that he receives monthly.
Your Honor, he takes 30 milligrams of Abilify daily, vitamin D3, 2,000 units by mouth daily, Depakote, 750 milligrams in the AM, and 1,000 milligrams at bedtime. cargentin, half a milligram twice daily, trazodone, 150 milligrams at bedtime, perfenazine, 4 milligrams, 1 tab, 3 times a day. It's also my understanding that Mr. Mejia has seizures, and if he does have allergies to certain seizure medication that's provided by the jail, if he were to receive that medication during one of his seizures, it could potentially be life-threatening.
I understand. I don't know how much, I mean, and I could be misremembering my time in mental health court, but at baseline means he's stable. At baseline means he's been on his medications for a period of time and that his conditions are maintained and managed and even, and he's had enough time for those medications to have the desired effect in helping him deal with the conditions that he has. So that's basically a layman's explanation of baseline, which is all that I can give you because I'm not a medical or psychological professional. So I understand what you're saying, and I certainly understand that the jail wouldn't be the most appropriate place to take care of his concerns, and B, that we would not want anything bad to happen in the process of waiting to see what happens in this case. However, I do have to balance that with the rights of the alleged victim, the fear and concern of his propensity to re-offend and his ability to be compliant with any court orders. So I'm trying to balance all of that. There is probable cause in the affidavit for the reason that he was arrested. And that does usually result in a 0 bond or a very high bond. So having heard everything that we've said so far about why you feel the jail might not be the best place for him and the Baker Act hold, I'm going to let the state respond on the record.
Your Honor, to my knowledge, Lauren Demers on behalf of the state, I was not made aware of any of this information until we were in court right now.
Right.
So without having the ability to contact the victim or the victim's mother, in this case, the fact that there's an admission and statements where this was not the first time this incident something like this had happened, the state does have concerns about an ROR first and foremost, and under the bond schedule, this is a capital sexual battery, and he is not entitled to bond. This might be something better flushed out with an emergency bond hearing this week in front of, I believe this case is assigned to Judge Nix. I have let the assigned ASA know that this case was coming in, but obviously not the extent of all of these extenuating factors. Not that I don't trust what PTR has, but the state hasn't had an opportunity to review those documents, talk to the victim about it. The state's position would be to hold him on the no bond status and possibly have a full-fledged bond hearing in the appropriate division so the victim can be present. They have a right to be here. The victim's mother has a right to be heard and be fully informed. And we just haven't had the opportunity to flush all of that out before the initial appearance today.
Let me ask PTR on this end, Mr. Reno, does Mr. Mejia have any previous criminal record? Any history?
No, Your Honor.
Okay. And I don't know if Ms. Hill has this information. You told me that there is a Baker Act hold. If Mr. Mejia is at baseline and he has, up until the time he was arrested, had access to his medication, what behaviors are you all seeing that you believe a Baker Act is appropriate?
Well, that would need to come from our mental health director, Ms. Mendoza.
Okay.
I don't have that information in front of me, but I did want to state that we did have contact with the alleged victim's mother, and she will not be in the residence. She is moving in with the brother, who I believe is present there in court.
Yeah, and the gentleman raised his hand, so that identifies who's here with the mom. Okay. So for the record, I'd like the record to reflect Mr. Mejia is standing next to the public defenders over there in the chapel of the jail. Very attentive, very calm, very alert, He does not appear to me from this distance, and I don't know him outside of what we're doing here today, but he appears to be, appropriately paying attention and calm and non-agitated. He doesn't look agitated at this moment to me. Not to say he wasn't before he came into court, not to say he can't be once he leaves court, but at this present moment, he appears very calm and alert to what we're saying. Normally, having done Baker Act hearings myself, the person that we're considering for the Baker Act petition must be exhibiting some signs, symptoms, or have made statements that would put the reasonable person at fear for his own safety or for the safety of other people in his presence. I'm not seeing that, but I also haven't read a report of what Ms. Mendoza may have experienced. I'm saying this all again to lay a record because it's a balancing act.
Perhaps it is not that he is displaying any erratic behavior at this time, but it's more of a preventative so that he can get the needed medication that's not available to him here at the jail, so that he does not go into a crisis mode.
I understand. I think that's a great way of wanting to try and help him, but that's not a basis for Baker acting somebody. Unfortunately, I don't know that if I were the hearing officer hearing that, I probably would not order the Baker Act, but I do want him to get the medication that he needs to get. So let me ask his mom or his brother who are here in the courtroom about the medications. Who normally gives him his medications? Either one of you is fine, whoever can answer.
It's either my mother or
The other sister? Yes. Okay, so they help give him his medications? Yes. And how often does he experience seizures?
I know when he's taking when he doesn't take a particular medication, if he doesn't have it, he'll have violent seizures.
How long between the missed medication and the seizure starting? How?
Matter of
Days, okay. And Ms. Hill, these are not medications that if the family provides them, they could be administered at the jail?
It is my understanding that they cannot due to the type of medications.
So they're not allowed to be brought into the jail?
That's my understanding.
Okay. Mr. Mejia, do you remember when was the last time you took your prescriptions?
Yes.
When was it?
Oh, last week.
Okay. And Ms. Hill, do you know which ones are not allowed in, or are they all not allowed in?
I do not have that information. We're getting that for you.
Okay, I appreciate that. In the meantime, I'll ask Mr. Marino on this end. I know he doesn't qualify for PTR because of the nature of the offense. Does that mean he also would not be able to do any type of electronic monitoring or house arrest or anything like that?
Fortunately not, Your Honor.
None of it?
Yeah, the charge doesn't qualify
Okay.
for the admin.
And let me ask the brother again, what is the living arrangement? Your sister and her daughter and your brother all live with your mom? Okay, so they all live with mom in mom's house? Yes. Okay, and then the sister and the daughter, so let me just put in here, Juritza and Najari are going to be coming to live with you? And where do you live?
I live in a separate apartment in Orlando.
But, okay, so not in Kissimmee, not in Osceola County, far away from where your mom's house is? Okay. And are they okay to stay with you for a little while?
I said I'll open the doors to my family as long as I can.
I appreciate that. No, I want to make sure I understand what's going on. Okay. Anything further from this state?
Your Honor, again, just without having time to review all the information, talk at greater length with the victim's mother. I mean, I understand we're hearing this from the brother, but we haven't had a chance to hear it directly from her under oath today. The state would object to a bond at this time. And I understand that there's a lot of moving pieces, and it doesn't mean the state may change their position in a few days, but there's just a lot of information that we're taking in just right now. And a case of this magnitude, these types of charges, the legislature says they're supposed to be held no bond for a reason. So it's the state's position that he should be held no bond, at least at this time.
I understand. I think for the record, I'd like to just mention that under circumstances that don't involve Mr. Mejia's mental health needs, the long list of medications that he's on, that for the rules that apply to the jail and to corrections are controlled substances that are not allowed to be admitted into the jail. The fact that he has no previous criminal history, that he has a mental age of, if I'm not mistaken in reading the diagnoses I was given, of about 12. And the fact that he is an adult in the care of his biological or adoptive mother, in the care of his legal mom, I would be giving a different ruling. But at this time, and this is going to be very strictly worded, so I'll tell the clerk, I'm going to grant the motion for release ROR because there is a Baker Act hold. He will be released to an agent of Park Place and no one else. So he may be released to Park Place. Park Place is to notify the court upon any release from their facility. I'm going to say it slowly so the clerk can write it down. He is to be in the custody and supervision of his mom. Ma'am, what's your name again? Maritza Delgado. He may not reside anywhere except Miss Delgado's residence. Until further order. He is not to have any unsupervised contact with anybody under the age of 18. So you can't leave him alone with anybody under 18. Okay? And he has to have absolutely no contact with Najari or Jaritza. At all. No contact. They have to stay in separate places. Okay? And for the record, the victim and the victim's mom have voluntarily left the residence. By the time he's done at Park Place, that would have given them enough time to get their belongings or whatever they need out of there. The family, and you don't have to put this in the order, I'm just telling them, the family needs to not try to make things nice between the two of them. This case has to get over first. Don't try to intervene and keep them separated. Because if one thing goes out of place, he's going back to the jail, without a doubt. And then I would like for this to be set in front of Judge Nix for release review as soon as possible. State, could I ask you to be in charge of seeing if you can get that coordinated?
Yes, Your Honor. I have typed up detailed notes for the ASA that's going to be handling it, and we'll ask her to reach out to schedule a release status with Judge Nix this week.
Because as you know, Baker Act is up to 72 hours with maybe one renewal of up to another 72 hours. So the longest he can stay without physically being found incompetent and committed would be that 6-day period of time. So that would give a little bit of time for this to get in front of Judge Nix.
And Your Honor, just for the court's information, we will be forwarding all our medical documents to the state so that they do have these medical documents. That's
fine. That's no problem. this is a unique situation, and this is for the protection of the victim who is who is out of the house. The family knows the distance requirements that need to be imposed. Mr. Mejia is an adult in need of services. And so we're trying to accommodate that so that his health doesn't deteriorate or that he doesn't suffer a major episode for not having access to his prescribed medications. And Park Place is involved. So this is not just like a direct a direct ROR out into the street. And so hopefully that makes sense. Next court date will be on demand, besides hopefully this release review hearing that can happen quickly. Anything further from the state?
Your Honor, I would just like to, if and when he's released from Park Place, I would just ask that PTR, before he is officially released, just confirms with the Mejias that they have left that residence before he goes back there.
PTR is not involved because he doesn't qualify for PTR supervision under the admin order. So it's more of a loose conditional release type of a thing.
Yeah, the state's just concern is we've heard from the brother, but we haven't actually heard from them. And we want to make sure that they are at a safe place, since they're not technically obligated to leave the home. They're volunteering, but we just want to make sure that paths don't cross, and that I'll have the victim advocate reach out as soon as possible as well, but
I'll tell the family and I'll tell Mr. Mejia, who's hearing me over at the jail, if Jaritza and Najari have not left mom's house, Johnny can't come back to the house. If they're still there, they're living there or they're visiting there, he can't be in the house anywhere near them. So if he gets caught anywhere around them, he's going to violate his release and go back to jail. So the important thing is to make sure that if she wants to leave, that she's gone before he comes home.
And Your Honor, we did speak directly to the mother of the alleged victim, and she did tell us that she is leaving to live.
I understand. Things changed, so I just wanted to make sure. What, sir?
I want to know how long the process from here to Park Place would take.
Should be today. They're going to probably try and arrange for him to get picked up by Park Place today so that he can get his medications. They should, but I don't know for sure. They have to, there's a process on how quick it has to move, but they're going to evaluate him. It could be less than 3 days. That's why I wanted to make sure everybody understood.
Who's going to be contacted for his release?
Well, hopefully they'll contact you all. Yeah, I mean, if you want to go to Park Place and give them your information, that's fine. Yeah. All right, any other questions? Okay.
And Your Honor, for the court's information, we have been in contact with the alleged victim's mother. We will provide that contact information to the state as well with the medical records. So
That'd be great. All right, thank you very much.
Thank you, Your Honor.
All righty, thanks.
Have a good day.
You too. We'll be adjourned. I have court tomorrow at 9, but IA's tomorrow at 1. Thank you.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
All right, good morning, folks. My name is Kurt Hitzman, County Court Judge here in Hernando County. You folks are here for your first appearance. Purpose of the first appearance is so that you may be informed of the charges against you. I'll determine if there's probable cause for those charges. Probable cause simply means it's more likely than not that a crime has occurred, and more likely than not that you're the person who committed that crime. Of course, as you stand before me today, I presume that you're innocent of these allegations. That presumption of innocence will stay with you through every stage of the proceedings unless and until the State Attorney's Office is able to prove the charges against you beyond and to the exclusion of a reasonable doubt. We'll set your conditions of pretrial release this morning. That is your bail or your bond. In most cases, you've had a bond set already pursuant to the bond schedule. Here in the 5th Judicial Circuit, or the warrant which led to your arrest, I'll determine if that bond should be raised or lowered or left the same, or whether there'll be additional conditions of pretrial release placed upon you. We'll let you know when your next court date will be. If you'd like to have the services of the public defender, I'll gladly appoint the PD to represent you this morning. You do have a right to have contact with folks on the outside, family, friends, counsel. Finally, and most importantly, you're advised that you do have an absolute right to remain silent with regard to the facts which surround your arrest. I encourage you to do that. These proceedings are recorded. In addition, there is an assistant state attorney in the courtroom with me. If you say something that tends to incriminate you, they will use it against you in the prosecution down the road. And I need each and every one of you there at the jail to please raise your right hands and be sworn. You all solemnly swear affirm, tell truth, whole truth, nothing but the truth? Outstanding. When you hear your name called, you can step forward. Jennifer Eubanks Godby. Morning, Jennifer. What's your date of birth?
12/15/84.
Jennifer, the charge grand theft, there's probable cause for that charge. As to that charge, you wish to represent yourself, you're going to hire private counsel. Would you like me to appoint the public defender?
The public defender, please.
I'll appoint the PD. State any history.
She has dealing in stolen property from 2017. And that's all I see.
All right. Jennifer, I have an address for you on Weeping Willow Street in Brooksville. Is that where you live?
Yes, sir.
How long have you been there?
About 8 months.
All right. Are you working these days?
Self-employed.
What do you do?
I clean houses, clean
Okay.
custodial.
All right. I'll set your bond at $500. I'll have you back in court on the 24th of May. Very important that you contact the public defender when you get out, all right?
Yes, sir. Thank you.
Thank you. Melissa Kincaid. Sorry. Morning, Miss Kincaid. What's your date of birth?
82.
All right. Ms. Kincaid, you're hearing a warrant that was signed by Judge Scaglione. He found probable cause for one count of a burglary of a conveyance with a battery. There's probable cause for that charge then. So as to that charge, you're going to represent yourself. You're going to hire private counsel. Would you like me to appoint the public defender?
PD.
I'll appoint the PD. State.
She has an assault from 2008, a theft from 2008. She has another theft from 2008, possession of controlled substance 2015, possession of controlled substance 2015, carrying a concealed firearm 2015. She has another possession of controlled substance from 2018, possession of controlled substance from 2018, another possession of controlled substance from 2018, another possession of controlled substance from 2018, possession of drug paraphernalia from 2018.
Okay. Melissa, I have an address for you on Crowell Road in Brooksville. Is that where you live?
Yes.
How long have you been there?
Almost a year.
All right. Are you working these days?
I stay home with my autistic son.
Okay. Melissa. It's an outside call. Weird. I'm going to set your bond, Melissa, at $10,000. Condition of the bond is that you have no contact with Miss Sauls. No contact means no contact of any kind. You don't call, you don't write, you don't email, you don't text message. Don't contact her through any social media. Don't go where she lives. Don't go where she works. Don't have a third person contact her. Any way that you might imagine contacting her, I forbid you to do that. If you have contact and we find out about it, your bond can be revoked and you can be held without bond until the charges are resolved. I'll have you back in court on the 25th. Is that right? We've been using the 24th already. On the 24th of May. If you bond out, make sure that you see the public defender right away, okay? Thank you. Alyssa Powell. Want to miss what's your date of birth?
October 19th, 1990.
Alyssa, this is a probable cause arrest for a violation of probation. There is probable cause for the VOP. As to that charge, you're going to represent yourself. You're going to hire private counsel. Would you like the public defender?
Public defender.
I'll appoint the PD. Bond, of course, is no bond. I'll have you back in court on the 24th of May. Public defender will come see you before then, okay?
Yes, sir.
Thank you. Shamar Cromwell. Want to start with your date of birth?
August 30th, 2001.
Tomorrow, I have 3 charges today: possession of hashish, possession of marijuana, possession of drug paraphernalia. There's probable cause for those charges. As to those charges, you want to represent yourself. You're going to hire private counsel. Would you like the public defender?
PD.
I'll point the PD. State?
No, Your Honor.
Nothing. All right. Young man, I have an address for you on Spring Haven Loop. Is that where you live?
Yes, sir.
How long you been there?
About 4 years now.
And are you working these days?
Yes, sir. I work at Taco Bell.
Okay. All right. On the hash, I'll set the bond at $1,000. On the marijuana and paraphernalia at $500. That's a total of $2,000. We'll have you back in court on the 24th of May. Make sure you reach out to the public defender when you get out. All right?
Yes, sir.
Thank you. Christopher Goodfellow. Hi, Chris. Date of birth?
January 16, 1980.
All right. So, Chris, now we have this warrant out of Pinellas County for the 2 counts of conditional release violation. So the Pinellas County judge set that at no bond. We'll give Pinellas 5 days to come get you so you can get this squared away in Pinellas County. All right?
Okay. What about I'm on probation too.
Well, that they'll have to. You're on probation out of Pinellas County.
No, here.
Okay. Well, that will be determined by the probation officer that you have. But for now, all I can tell you is they got this warrant in Pinellas, and you'll be there in the next couple of days. All right?
Okay. I gotta pay his bondman like $300 too. Up there, Clearwater.
Well, I don't know about that, but I know this warrant is no bond, so you can't get out until you get in front of a judge in Pinellas County. So that's the next thing we're gonna do. Is have Pinellas come and get you in front of a judge in Pinellas. Okay?
Okay. In 5 days.
5 days I give them 5 days to come get you. That should be quicker than that even, okay?
Okay.
All right. Thanks, Chris.
All right, stop.
Andre Mills. Morning, Andre. What's your date of birth?
9/30/77.
Andre, you're hearing a warrant signed by Judge Helis, apparently for failing to appear on a no valid driver's license. State, is this something he can resolve this morning?
Judge, he has a lengthy history, so if he wants to resolve it, it would not be something he'd probably want.
Okay.
We could do 11/29.
Well, it's a secondary misdemeanor, so you can do 60.
60 days.
All right. Andre, I'm guessing you don't want to do 60 days on this?
60 days. Oh, shit. I almost got it in, so.
I'm sorry, Andre, I didn't understand you.
I almost have all the time in, so.
Oh, really?
We could run it, yeah.
Where have you been in jail? In Pasco?
Yeah.
How long were you in jail down there?
I did about 24 out there, and, it's like, I've been arrested for the same charge, like here and there.
It looks like 3 times at least on this one.
Yeah. That's all I've been arrested for is this charge right here, because it's hard to get back and forth.
Okay. Can we, at the jail, can we confirm how much time Andre was in Pasco? Or Craig, is that something you can get to? Okay, hang on, Craig's got it. Hang on a second, Andre.
Okay.
Because he must have probably got 6 or 7 here.
Yeah, it looks like from the 21st to the 28th, the most recent one. Then the one before that was
8.
back in 2020. Is this a?
This is a 2020.
Okay, gotcha.
339 CT.
All right, he was showing from 12/15/2020 to 1/1. So that'd be another 17 days. Plus the 8 is about 25.
25. Plus whatever he's got here. Hang on.
Another 2 days in October of 2020.
Here or there?
There, Pasco. Everything else before that's 2019.
Okay. All right. So Andre, if you wanted to take the 60 today, I've got you with 29, which would mean you'd have 11 left to do.
I'll take that.
All right. You understand by entering a plea today? That's right, right?
21.
21. That's because 60 is 50. Oh, 21. 21 days, Andre. You still want to do it?
Yes, sir.
You understand by entering a plea today, you give up the right to have a trial by jury, the right to confront the witnesses against you, the right to remain silent, right to have a lawyer, but you want to give up those rights so we can take care of this today?
Yes.
Case number 20 CT 339 has to charge a no valid driver's license. How do you wish to plead? You can plead no contest.
No contest.
Accept that plea, find it was freely and voluntarily made. I'll adjudicate you guilty, sentence you to 60 days with credit for, what do we say, 29? 29 days served. Fine in court costs is $450. I won't order coin since you're going to do the bulk of the time out of county. So that takes care of it. You got about three weeks left, Andre, and this is over, all right?
All right. Thank you.
Thank you. Jonathan Pofero de la Rosa? Or is that my interpreter case? I don't even know. Morning, sir. What's your date of birth?
020603.
It's not. 3 charges today, Jonathan. Possession of hashish, possession of marijuana, possession of drug paraphernalia. As to those charges, you want to there's probable cause. You want to represent yourself. You want to hire private counsel. Would you like the public defender?
I'm PD.
All right, PD, state.
No prior.
Okay. All right. And Jonathan, I got an address for you on Locker Drive in Spring Hill. Is that where you live?
Yes.
How long you been there?
5 years now.
All right. Are you working these days?
Yeah, I work at Carruthers on 50.
Okay. Set your bond on the hash at $1,500 on the other 2 charges for a total of $2,000. Have you back in court on the 24th of May. Make sure you get with the PD when you get out, all right?
All right, thank you.
Thank you. Zachary Westendorf. Morning, Zach. What's your date of birth?
07/31/2003.
Zach, you got 4 charges today. There's a fleeing to elude and reckless driving, operating an unregistered motor vehicle, and failure to have your motorcycle endorsement. There's probable cause for those 4 charges. As to those charges, you want to represent yourself. You're going to hire private counsel. Would you like the public defender?
Public defender.
I'll point to PD. State.
I don't see any prior.
All right. And Zach, I have an address for you on Clarendon Court in Spring Hill. Is that where you live?
Yes, sir.
How long have you lived there?
Only like a month.
All right. Are you working these days?
Yes, sir.
What do you do?
I work at Publix.
Okay. All right. On the fleeing and the reckless, I'll set the bond at $500 each. On the 2 other misdemeanors at ROR, your total's $1,000. I'm going to have you back in court on the 24th of May. Very important that you reach out to the public defender when you get out, all right?
Yes, sir. Thank you.
All right. And then Heriberto de la Cruz.
Over here. Your Honor, this is going to be your interpreter.
Okay, Okay, I'll come back to it. I'll come back to it. Sean Barkley. Want to Sean, what's your date of birth?
6/13/75.
Sean, you're here on a warrant signed by Judge Toner. You found probable cause for a violation of probation. As to that charge, you're going to represent yourself. You're going to hire private counsel. Would you like the public defender?
Public defender.
I'll point the PD. Judge Toner set your bond at no bond. I can't change that. I'll move you to the 19th of May. That's his docket. Public defender will come see you before you go to court, okay?
Thank you, sir.
Thank you. Joseph Condren. Morning, sir. What's your date of birth?
12/25/1980.
Joe, the charge is battery being domestic in nature. There's probable cause for the charge. As to that charge, you're going to represent yourself. You're going to hire private counsel. Would you like the public defender?
Public defender.
I'll point the PD. State.
Judge, I haven't seen any priors.
All right. And Joe, I have an address for you on Hickory Street in Brooksville. Is that where you live?
Yes, sir.
How long have you lived there?
4 months.
All right. And does Cookie live there?
No.
No, she doesn't. Okay. All right. Are you working these days?
Yes, I have a property management business.
Okay. You work for yourself?
Yes, sir.
Okay. All right. I will set your, Joe, I'll set your bond at $500. Condition is that you have no contact with Cookie while this charge is pending. Did you hear me explain no contact earlier?
Yes, sir.
You understand that?
Yes, sir.
Very good. Have you back in court on May 18th. Make sure you check with the PD when you get out, all right?
Thank you.
Thank you. Robert Cunningham. Want to start with your date of birth?
4/15/86.
Robert, you're here on a warrant that was signed by Judge Toner. He found probable cause for a violation of probation. As to that charge, you want to represent yourself. You're going to hire private counsel. Would you like the public defender?
PD.
I'll point the PD. State. Oh, it's no bond. Judge Toner set your bond at no bond. I can't change that, Robert. We'll have you back in front of Judge Toner on the 19th of May. Public defender will come see you before that, all right?
All right.
Thank you. And Joe Cothard. Run again, Joe, date of birth?
7/11/81.
All right, so this is a warrant out of Sumter County. The judge that signed the warrant thinks you failed to appear on 4 charges. I got possession of meth, resisting without, possession of paraphernalia, and driving on a suspended. The total bond is $9,000. If you can post that bond, then you can go over to Bushnell and find out when they need you in court. If you can't post it, Sumter will have 5 days to come grab you, all right?
Yes, sir.
Thank you. And then is Stephen Yeager in custody?
Yeah, I believe so.
Is Stephen Yeager there?
Yes, sir.
Craig Brown, on behalf of Mr. Yeager.
All right, and what are we doing?
Mr. Yeager has a VOP for battery. I believe the recommendation for the state's 120 days.
Right.
And the credit for time served between Hernando and Pinellas appears to be 89 days.
Okay.
I believe Mr. Yeager was going to admit to the violation.
All right. So, Mr. Yeager, you want to admit a violation? I'd give you 120 days with credit for 89, which would give him 11.
Yes,
11
sir.
left to do.
Yes, sir.
All right. Stephen, you understand by entering an admission, you give up the right to have a trial by jury, the right to confront the witnesses against you, or trial to the court, the right to confront the witnesses against you. But you want to give up those rights so we can take care of this today?
Absolutely.
Case number 21MM50, do you admit that you violated your probation?
Yes, sir.
I'll accept the admission, find it was freely and voluntarily made, revoke and terminate the probation unsuccessfully, adjudicate you guilty of the underlying charge. If we didn't do that, sentence you to 120 days in the county jail, credit for 89 served. It's $100 cost of prosecution for the state, $100 for the PD, and he did a lot of it out of county, right? I won't order a warrant today because most of the time was out of county. But that takes care of it, Stephen. Like I said, it looks like about 11 days left to do.
Yes, sir. Thank you very much.
Thank you. Good luck. All right. And then, Jill, I'll get that Zoom up. let Joe know? Did you let Joe know?
Yes.
Oh man, everyone's already there. Zoom. Just wait for the interpreter. Did he already post bond on the burglary?
Yes.
Okay.
They should be joining now.
Morning, Sandra.
Good morning.
Sandra, this is Heriberto de la Cruz.
Alberto de la Cruz.
And sir, what's your date of birth?
Señor, ¿cuál es su fecha de nacimiento?
Agosto 9 del 74.
August 9th, 1974.
And Mr. de la Cruz, I have a warrant for you out of Pinellas County.
Señor de la Cruz, tengo una orden de arresto del condado de Pinellas.
The judge that signed the warrant believes you failed to appear on a charge of loitering and prowling.
Señor, el juez que firmó esta orden por incomparecencia en cargo de ensuciar en lugares públicos.
And that judge set your bond at $513.
Ese juez puso una fianza para usted de $513.
I don't have any authority to change that bond.
Yo no tengo autoridad para cambiar esa fianza.
So if you can post that bond, then you can go to St. Petersburg and find out when they want you in court.
Entonces, si usted sale libre bajo fianza, usted puede ir a San Petersburg y ir a la corte para ver cuándo está bien.
If you're unable to post that bond, I would give the folks in Pinellas County 5 days to come and pick you up.
Entonces, si usted no puede pagar la fianza, les diría a las personas, las autoridades en Pinellas, que tienen 5 días para recogerlo a usted.
Very good. Any questions?
¿Preguntas?
Sí. Yo nunca fui arrestado en Pinellas. Es la primera vez que me arrestan.
I was never arrested in Pinellas. This is the first time I am arrested.
Okay. Well, unfortunately, it's an out-of-county warrant. All I can do is tell you we have the warrant, and it's been confirmed, and you have to go to Pinellas to clear it up.
Entonces, desafortunadamente, esta es una orden de arresto por el condado y ha sido confirmado que usted tiene que ir a Pinellas. Perfect, okay.
Very good. Thank you.
Judge, can I have a case here as well?
He pawned it out on that.
Oh, okay, sorry. It was
All right. Thanks. Thanks, Sandra.
You're welcome.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond Court viewers hit the like button, and less than 1% leave a comment. If you want Bond Court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.